Welcome to the Point. In this session, let's discuss about fundamental rights. So this fundamental rights, it is enshrined in part 3 of our Constitution and articles from 12 to 35, it mentions all the fundamental rights. The concept of fundamental rights, it was derived from the inspiration from the Constitution of USA. That is Bill of Rights. Part 3 of our Constitution, it is described as Magna Carta of India. Why? Because it contains a very long comprehensive list of justiciable fundamental rights. The fundamental rights, they are guaranteed by the Constitution to all the persons without any discrimination, and they uphold the equality to all the individuals, the dignity of the individual, and the larger public interest and unity of the nation. Fundamental rights, they also promote the idea of political democracy. They prevent the establishment of authoritarian and despotic rule in our country. The fundamental rights, they are named so because they are guaranteed and protected by our Constitution, which is the fundamental law of the land. Originally, our Constitution provided 7 fundamental rights. They are right to equality from Articles 14 to 18, right to freedom, which deals with Articles 19 to 22, right against exploitation, Articles from 23 to 24, right to freedom of religion, Articles from 25 to 28, cultural and educational rights, Articles from 29 to 30, and right to constitutional remedies, Article 32. And initially, our Constitution also contained right to property, Article number 31. But it was deleted from the list of fundamental rights by the 44th Amendment Act 1978. Features of fundamental rights. The fundamental rights, they are guaranteed by the Constitution. And let's discuss how the fundamental rights are characterized. Some of the fundamental rights, they are available only to the citizens, while others are available to all the persons, whether citizens, foreigners, or legal persons like corporations or companies. Fundamental rights, they are not absolute, but they are qualified. This means that the state can impose any reasonable restrictions on fundamental rights. So whether such restrictions is reasonable or not, all these things, it should be decided by the court. And this is how they strike a balance between rights of the individual and those of the society as a whole. Most of the fundamental rights, they are available against the arbitrary action of the state, with a few exceptions like those against the state's action and against the action of private individuals. Some of the fundamental rights, they are negative in character. That is, they place certain limitations on the authority of the state. Fundamental rights, they are said to be justiciable. That means it allows a person to move to the courts for their enforcement if they feel that the fundamental right is violated. Fundamental rights are defended and they are guaranteed by the Supreme Court, so that the aggrieved person or the affected person, he can go directly to the Supreme Court, and it is not necessary for the affected person to appeal the judgment of the High Court. Fundamental rights are not sacrosanct or permanent. The Parliament, it can curtail or repeal them, but it should be done only by the Constitutional Amendment Act and not by ordinary act. And this amendment in the fundamental right, it should not affect the basic structure of our Constitution. Fundamental rights, they can be suspended during the operation of national emergency except the rights that is guaranteed by Article 20 and 21. What is the definition of a state? The term state, it has been used in different provisions regarding the fundamental rights, and hence Article 12, it defined the term for the purpose of Part 3, that is, according to Article 12, the state includes government and the Parliament of India, that is the executive and legislative organs of the central government. Government and legislatures of the state, that is executive and legislative organs of state government. All the local authorities, that is municipalities, panchayats, district boards, improvement trust, etc. All other authorities, that is statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. Now, state has been defined in a wider sense, so it can include all its agencies. It is the action of these agencies that can be challenged in the courts as violating fundamental rights. And according to Supreme Court, even a private body or an agency working as an instrument of the state comes under Article 12. Laws inconsistent with fundamental rights. Article 13, it declares that all laws that are inconsistent with or in derogation of any fundamental rights, it shall be void. So, in a simpler way, we can say that Article 13, it provides for the doctrine of judicial review. This power has been conferred on Supreme Court under Article 32 and High Courts under Article 226. This can declare a law unconstitutional and invalid on the grounds of the fundamental rights. The term law in Article 13 means permanent laws enacted by the Parliament or the state legislature, or the temporary laws like ordinances issued by the President or the state governors. Statutory instruments in the nature of delegated legislation, like executive legislation, like order, bylaw, rule, regulation, or notifications, and non-legislative sources of law, that is custom or usage having the force of law. Thus, not only a legislation but any of the above, it can be challenged in the courts as they are violating the fundamental rights, and hence this can be declared void. Right to equality. It includes 5 laws. They are equality before law and equal protection of laws. It comes under Article 14, and Article 14, it says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The concept of equality before law, it was from British origin, and the concept of equal protection, it was taken from American Constitution. And equality before law, it says that the absence of any special privileges in favor of any person, and the equal subjections of all the person to ordinary laws of the land, which are administered by the ordinary law courts. And no person, whether he may be rich or poor, high or low, official or non-official, no one is above the law. And equal protection of law. This concept, it states that the equal treatment under equal circumstance, the similar application of the same laws to all the persons who are similarly situated, and they should be treated without any discrimination. Prohibition of description on certain grounds. Article 15 provides that The state shall not discriminate any citizen on the grounds of religion, race, caste, sex or place of birth. Prohibition of description on certain grounds, it comes under Article 15. And Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on the ground of only race, religion, caste or sex or place of birth. With this regard, they have the access to shops, public restaurants, hotels and places of public entertainment. And also they have access to wells, tanks, bathing ghats, roads and places of public resort, etc., which is dedicated to the general use of public. Everyone has an equal right on the public properties. Equality of opportunity in public employment comes under Article 16. Article 16, it provides equality of opportunity for all the citizens in matters of public employment or appointment of any office under the state. And here, any citizen is not being discriminated or he is ineligible for any employment of office under the state on the grounds only of religion, race, caste, sex, descent, place of birth or residence. But apart from this, there are 3 exemptions to this general rule of equality of opportunity in public employment. Parliament, it can prescribe certain residence as a condition for employment or appointment in a state or a union territory or a local authority or other authority. The state can provide for reservations for appointment of post in favor of any backward classes. A law can provide the incumbent of an office related to religious or denominational institutions. Abolition of untouchability comes under Article 17. Article 17, it abolishes untouchability. The term untouchability, it has not been defined either in the Constitution or in the Act. In 1976, the Untouchability Offences Act 1955, it has been amended and renamed as Protection of Civil Rights Act 1955 to enlarge the scope and to make a penal provisions more stringent. And this act, that is the Protection of Civil Rights Act, it defines civil right as any right occurring to a person by reason of abolition of untouchability under Article 17. Under the Protection of Civil Rights Act, the offences committed on the ground of untouchability, they are punishable either by imprisonment up to 6 months or by a fine of up to 500 or both. Abolition of titles under Article 18. This prohibits the state from conferring any title except a military or an academic distinction on anybody, whether a citizen or a foreigner. It prohibits a citizen of India from accepting any title from a foreign state, and a foreigner holding any office of profit or a trust under a state, he cannot accept any title from any foreign state without the prior permission of the president. And no citizen or a foreigner will hold any office of profit or a trust under the state, and that citizen should not accept any present or emoluments or office from or any foreign state without the prior permission of the president. Right to freedom. Protection of 6 rights. Article 19, it guarantees to all the citizens the 6 rights, and they are right to freedom of speech and expression. So this statement states that every citizen has a right to express his views, opinions, beliefs and convictions freely by word, of mouth, writing, painting, picturing, or in any other form. And the Supreme Court held that the freedom of speech and expression, it also includes right to propagate one's view, freedom of press, freedom of commercial advertisements, right against tapping of telephonic conversation, right to telecast, right against ban, which is called by a political party or any organization, and right to know about government activities, freedom of silence, right against imposition of pre-censorship on a newspaper, and right to demonstration or picketing but not right to strike. Right to assemble peaceably and without arms. Every citizen has a right to assemble peaceably without arms, and this includes the right to hold public meetings, demonstrations, and take out processions. And this freedom, it can be exercised only on public land. Freedom to assemble. This right, it does not include the right to strike. A right to form association or unions or cooperative societies. All the citizens have the right to form associations or unions, but it includes right to form a political parties or companies, partnership firms, societies, clubs, etc. It not only includes the right to start an association or union, but also to continue with the association or union. So this right, it covers a negative right of not to form or join an association or an union. Right to move freely throughout the territory of India. This freedom of movement. This freedom, it entitles every citizen to move freely throughout the territory of the country. That is, a person can move from one state to another or from one place to another within a state. Right to reside and settle in any part of the territory of India. It is freedom of residence. Every citizen, they has a right to reside and settle in any part of the territory of the country. And this right has two parts. The right to reside in any part of the country, which means to stay at any place temporarily, and the right to settle in any part of the country, which means to set up a home or a domicile at any place permanently. Right to practice any profession or to carry on any occupation, trade or business. Freedom of profession. All citizens are given the right to practice any profession or to carry out any occupation, trade or business. And this right, it is very wide as it covers all the meaning of earning one's livelihood. And also remember, freedom of profession, it does not include the right to carry on a profession or business or trade or occupation that is immoral, like trafficking of women or children, or any dangerous or harmful drugs or explosives, etc. The state can absolutely prohibit all such illegal activities to regulate them by giving a license to the profession.